The Supreme Court has held that the National Green Tribunal should act within the contours of the powers conferred on it by Section 15 of the NGT Act 2010. The Apex Court also made it clear that the power to carry out prosecution under the PMLA is not available to the tribunal. The appeal before the Apex Court challenged the order of the tribunal. The Division Bench of Chief Justice of India, B.R. Gavai and Justice K. Vinod Chandran observed, this court has also raised serious doubts about the jurisdiction of the NGT to direct the prosecution of individuals under the PMLA, which we fully subscribe to. The NGT should act within the contours of powers conferred on it, which is Section 15 of the NGT Act of 2010. Though such power would be available to a court constituted under the PMLA or to constitutional courts, it would not be available for exercise by the NGT constituted to ensure effective and expeditious consideration of cases relating to environmental protection and conservation of forests and other natural resources, including enforcement of any legal right and giving relief and compensation for damages to persons and properties. The respondent, who was the applicant before the National Green Tribunal, alleged that the appellant as an industry was actively perpetrating environmental degradation and pollution as well as extracting groundwater, thus polluting the surroundings and also releasing effluents into the nearby river, which is a tributary of the Ganga. It was also alleged that the other official respondents, the Pollution Control Board of the state and the Central Groundwater Authority and the District Collector, were mute spectators to the activities of the appellant and often colluding in polluting and damaging the environment. The proceedings before the NGT extended over a period of 3 years in which various reports were called for and the matter was disposed of with certain directions with which the appellant was aggrieved.